my book on idea and methods of legal research and other books. Of course, when I wrote that book, it was with the intention of filling a gap in the field of knowledge that I did it, thinking that almost 2 decades of teaching of a legal research method in various institutions should be put into some concrete work. And in course of time, I wrote several articles, compiled them, and brought it in this particular form. Idea and methods of legal research is product of that. In fact, Indian legal research has undergone a sea of a change. During last 30 years, there has been a shift to the uh, practical dimensions or empirical dimensions. And even in academic circles also, we come across more number of PhD works, more number of LLM dissertations using empirical methods of legal research, in addition to a doctrinal method of legal research. That's a combined method of legal research or a multi-method legal research or ecclesiastical method. That is something given a lot of emphasis, and I think that it is uh, towards the right direction. Perhaps several reasons might have contributed towards that. One is emergence of a national law school system of conducting research, which had exposed to the uh, uh, Western method of conducting a legal research through empirical study, especially Mark Galanter's works or George Godboy's work on judiciary, or various other works, or even works uh, done by some sociologists, maybe J.S. Gandhi and various other persons. All these had some focus on empirical method of legal research. How to conduct empirical method? They had a very good training from the Western world. Further, on the basis of the study of Indian social circumstances, they consider that it is more appropriate that in India, legal research should be taken forward through empirical method. Uh, of course, the Law Commission also changed its attitude. Law Commission, instead of confining to doctrinal method of legal research, increasingly employed multi-method legal research, and it began to publish questionnaires, or it began to organize various uh, say seminars or workshops in various parts of the country. For example, when the Hindu Succession Act was going to be amended, it was preceded by Law Commission's report, and the Law Commission had conducted a series of discussions in various parts of the country. It brought out one questionnaire, and it brought out one working paper. Of course, National Commission to the working of the Constitution, that had also used multi-method legal research. It issued, or it notified a number of working papers in various fields, and called for information. There's an interaction between a society and the researching agency was attempted in a very serious manner, and it was quite successful. And when it consolidated its report, it acknowledged the input that was given by the society. Not only Law Commission and these bodies, but even special commissions are constituted. For example, Dr. Veerapalli Commission on Administrative Reforms Commission, Administrative Reforms, or Punchi Commission on Center-State relations. There, of course, our eminent legal scholar, eminent educationist, Professor N.R. Madhavamenon was a member, and perhaps he was responsible to involve as much as a possible the non-doctrinal method or empirical method. That's why once again notification of a number of papers, then conducting of a discussion, through questionnaire or various other methods. These were very seriously attempted. Further, in academic circles, when PhD students chose topics for legal research, they did not confine to doctrinal method of legal research, because globalization had changed the scenario, and legal education has undergone change, and more and more focus on the law society interaction made them to select such topics and design the research method in such a way that the empirical method could be used as far as possible. Thus, either a quantitative legal research or qualitative legal research were brought into the field of legal research in almost all spheres. Further, we come across so many LLM dissertations which are also focusing on say empirical study. For example, about the position of street vendors, or about the position of say displaced workers or displaced persons, or the position of persons evacuated from certain places, or the position of persons who are say made free from some of the practices like devadasi or temple prostitution or such things, or persons who are subjected to, say, bonded labor or child labor. Concerning all these bodies, they consider that it is appropriate to conduct legal research by using an empirical method. Further, so many funded researchers in various universities, maybe funded by UNICEF or ICSSR or UGC or various other funding agencies, they insisted that unless empirical component of a legal research is not included, they will not be approving or they will not be sanctioning the fund. Thus, when fund providers insisted that there shall be such a empirical component, then invariably the legal researchers chose for those types of legal researches which involve a certain amount of empirical study or qualitative research, or even quantitative research. Of course, quantitative research was given adequate attention by the scholars in the field of jurimetrics, and also persons who researched about Supreme Court's performance. Yes, Nichols, Robinson, and various other scholars who researched about Supreme Court's performance. They use the numbers relating to Supreme Court, number of cases pending and number of cases disposed, number of cases relating to human rights, child rights, and various other things. Then we find that this yes, National Human Rights Commission, Child Rights Commission, or National Commission for Women, National Commission for Scheduled Caste, Scheduled Tribes. All these bodies used empirical method of conducting research. For example, when children were subjected to certain types of exploitations, maybe sexual exploitation or exploitation in workplace or various other types of exploitations. See, investigating about the incidents of such exploitations and the method of protecting them from such exploitations, all these required some field work or some empirical study. So on the basis of actual social experience that these things should have been conducted. That's why the National Commission for Child Rights, in its report, mentions about the method of empirical study that shall be invariably used in the course of such a legal research, especially about action research. There is such a mention. See, when a Ministry for Law and Justice announces or notifies the fellowships for research, it exclusively makes it available to action research. What is action research? Action research is one where, in collaboration with the affected community or participants, when the legal researcher conducts research by using an empirical method, then it is called as action research. Then policy research is also one where about the formulation of a policy, research is conducted not in a traditional manner, but in a different manner. There's a alternative policies will be examined. Their pros and cons will be threadbare analyzed by applying multi-method legal research. That is a policy research. See, action research is employed to find out the prevalence of certain practices like Kapu Panchayat practices or honor killing or various other types of deviant practices, even about witch craft or witch hunting or various superstition based crimes or crimes which were triggered by say unusual beliefs or unusual practices. See, concerning all these things, when researchers were conducted, they made use of sociological method. See, in all these spheres, whether law could develop its own method of legal research, it is not possible to answer in a very definite manner, because the essential method that's followed in the field of law is analysis of law or identification of its application or say identification of its evolution and how it is useful to the society, etc. But about impact analysis of law or about its importance or say the defects in such a law, etc. See, using some other method, like a sociological method, becomes appropriate. And when a quantitative research is to be conducted, going to the field of statistics and taking the help of specialists in the field of quantitative research, that becomes quite appropriate. See, one need not feel shy about say using the methods of research conducted in other disciplines, because knowledge is basically an interdisciplinary discourse. Without an interdisciplinary approach, it is not possible to generate a knowledge in modern times. That's if somebody says that law has no independent method of its own, but it depends upon the methods of other disciplines. Of course, it's possible to answer in this way that the doctrinal method of understanding the legal principle in the light of inductive logic applied to the field of precedents and knowing the exact legal position on the basis of such a study is a unique system. It is a unique approach of law. Similarly, about a legal policy or about analysis of that law or the legal profession's usual method of understanding what the law is. All these have provided some input for legal research. About that there is no doubt, and this is unique. Thus, to some extent, we can say that legal method is also independent method, but it cannot be that independent, because when it comes to the issues of application of law in the society and assessing its performance in course of time, it is essential that the researcher has to make use of me- research methods that are available in other fields as well. Thus, it is not necessary to say that um, particular discipline should be totally self-sufficient and independent insofar as research is concerned. See, what will be the types of flowers, uh, what will be their colors, or what will be their kinds. The bee, honey bee, does not find it as something very much relevant for uh, making such a distinction. It draws a nectar from for the flowers, which it finds as suitable and tasty, and it builds up the honey comb, or the whole of its a work product is something available to the society or available to the living beings because of the because of the selective use of various sources. What I intend to point out is that do not bother about the source, or do not bother about a specific method. How you are making use of that method in your individual circumstance, and uh, coming out with a good amount of contribution, that becomes essential. From that angle, we have to examine what type of method is to be employed. See, today's topic is a qualitative legal research. Qualitative legal research is a primarily one type of empirical legal research itself. Broadly, legal research can be classified into two: doctrinal and non-doctrinal. Non-doctrinal is also called as a empirical method of legal research, and empirical method of legal research uh, is not an alternative, but it is a supplemental to the doctrinal method. The uh, so-called competition, conflict, or choice between a doctrinal method and non-doctrinal method. All these issues are foregone issues. We are living in the era of convergence, confluence, and we are to make use of various tools that are available in a uh, both doctrinal legal research and non-doctrinal legal research. When I wrote this book on idea and methods, I just confined to the methods that were uh, most essential. But I found that some more method could also be there. In my subsequent article about archaeological legal research, I made it quite explicit, or I elaborated that issue, how archaeological research can be conducted in the field of law. See how it is essential, etc. In a Journal of Indian Law Institute, it was published. It is not just to resolve some of the legal disputes. Even going beyond that, archaeological research has its own contribution to make. That's in addition to those methods that are listed in my book, there could be some more methods also about the use of computer, or so many other things. There could be such a methods. I am not saying that any book on a legal research method can be exhaustive, or it can be considered as something uh, perfectly uh, suiting the circumstance in all situations, because uh, uh, there may be some new method, or the legal researcher himself or herself can innovate some new idea, new proposition, etc. Even about statistical research, there could be some other method. Even related to qualitative research also, we come across more and more application of, say, computer-based analysis of qualitative data. See, I have not discussed that part in my chapter. Of course, it's a bit technical. I do not have that much of acquaintance with that area. See, insofar as empirical legal research is concerned, it means that how law works in a practice, how laws are made, and how they function, and how the legal institutions function, and what the impact of application of law. All these are spheres of discussion for empirical legal research. Arati discussed how analysis of all the dimensions of law becomes essential. There's a making of law, then yes, implementation of the law, then assessing the impact of law, and so many other areas. These are all to be discussed in a holistic manner. Empirical legal research uses direct methods. For example, observation is a direct method. There's from the very society, it collects data and it makes analysis. Then it's largely based on observation as the method. See, observation is one of the ancient method of conducting research. Observation. See, in the field of science or in the field of social studies, we come across observation as the most ancient and authentic method of conducting research, because on the basis of actual experience that one will be verifying, one will be building theory, and one will be arriving at appropriate conclusions. See, and, under empirical method, we come across two specific methods. There's a qualitative research and quantitative legal research. Insofar as qualitative legal research is concerned, I should point out that its main attention is on the words that are constituting the data. Words. See, numbers constitute the main domain of quantitative research, whereas the words constitute the domain of qualitative research. See, legal world is full of words. Is full of words. There will be narration about the facts. There will be explanation about the legal philosophy. There will be formulation of a legal policy through various reports, once again in the form of words. And when administration gathers the data, again through words that it does. When parties come to the court and explain about the factual circumstances, again narration of words. For example, incident of rape, about that through verbal narration the matter is brought to the court. Maybe written narration or oral narration, but a narration will be there through words. Then a whole of a judicial process, arguments or examination, cross-examination, and so many things. Words, then a judgment full of words, and appeal, again words, and of course, there's a doctrinal legal research exclusively, it more substantially makes use of the domain of words. About that very smooth. But how in the field of qualitative legal research, the narration through words actually depict the natural scenario, that becomes quite important, because when a legal researcher conducts his research, he tries to find out objectively what is the society's intimate experience, what is its emotion, what is its feeling. So from the natural setting of the society, the narration is taken by the researcher, and he employs various tools for that purpose. He makes use of the tools like observation, questionnaire, case study, ethnographic study, or a focused group discussion, etc. Through those tools, he collects all such information, and uh, his focus is on the social experience as reflected through the uh, narrations of the natural setting of the society. How about a social problem or human problem? The society has a distinct experience about that. The legal researcher gathers data. See, the legal researcher in the field of qualitative research uh, makes use of a participatory method under observation as a tool of data collection. He makes use of ethnographic study uh, because qualitative research fundamentally depends on watching the people in their own territory and interacting with them in their own language on their own terms. See, in their place, visiting them, then in their own language, asking questions in an intimate manner, in a friendly manner, not with an ego of a superior person that he is a researcher and the other person is uh, simply a participant, but with a sense of responsibility that he has to get the data from the society in its natural setting. In that way, he conducts a research and gathers the data. See, observation as a tool of study enables that kind of building a rapport with the people, and it unearths or it uh, gives all such information which are shaped by the lives of people in their social, cultural, economic, and physical context. See, the experiences are composite. Uh, Experiences have several dimensions: social, cultural, economic, political, and physical dimensions might be there. For example, when you go to a tribal community for conducting research about the identification of social customs and to what extent they follow those social customs, or whether they consider that modern legal principles are more attractive than their own social customs, or whether still they are happy about the social customs. About that you are conducting research, or about their land holding you might be conducting research. What is the extent of land you have got, uh, you had inherited, and how you are using it, what are the natural resources available, whether water facility is available, or whether governmental assistance is available. About all those things, you are conducting research. See, you can be part of that society, or at least you have to establish some amount of a rapport with them. You are not an outsider, but you are a person who is seriously interested in their welfare, and in order to help them by providing some information to the policymakers, uh, uh, then their interest will be served in a better manner. Suppose you convince them and get their consent for a sharing of their views, then of course they speak out. People in a rural area, or women, or say people in a such a specialized circumstances, or people who are vulnerable, may not be so much exposed to these niceties of research, etc. That's why they might be hesitating. But suppose they consider that you are a part of their community, or with you, it is possible to share, and it is profitable to share their grievances, or their views, or their viewpoints. Then, of course, they'll be opening up. They'll be coming with their thoughts. They'll be articulating their ideas, and they'll be expressing. There's when through such appropriate methods like observation, or a focus group discussion, or content analysis, etc. Suppose you gather data in an intimate manner, then it is possible to know their real situation. That's why it is a quality. See, the word qualitative research came into vogue because of its a focus on the emphasis on natural setting of the society from which the data is gathered in a pristine and pure manner. Direct method, observation, or case study, or such a method, or through say interview and other methods. Suppose you uh, collected data, then it becomes quite intimate, and there the researcher makes use of such tools. In fact, between a qualitative legal research and quantitative legal research, the distinction is uh, only relating to the type of data, while qualitative data is more relying on words. uh, Quantitative data is relying on numbers. Of course, uh, their approaches are different, because there'll be more objective and scientific approach insofar as quantitative research is concerned. There's either it's a collection of data, or organization of materials, or say presentation of the materials, then analysis and interpretation. In all these spheres of or all these stages of a quantitative legal research, the researcher will be making use of uh, such a study in a in an objective and scientific manner. But that much of a scientificity or objectivity might not be there in the case of a qualitative legal research. In a qualitative legal research, a certain amount of subjectivity is bound to be there. For example, in a certain parts of a say backward area, uh, because in most of the circumstances in a backward areas, that these blind practices resulting in some of the uh, criminal acts, like witch hunting, or say uh, human sacrifice, or such instances that take place. Earlier, not only earlier, even now also, so many states where a tribal population is a thick and it is a wide. There we come across a uh, occurrence of witchcraft or witch hunting or say uh, human sacrifice, etc. Whether it's Jharkhand or Chhattisgarh, Odisha, or Madhya Pradesh, etc. These were considered as a or even certain parts of West Bengal. Uh, see, some of the northeastern states also that was experienced, but in course of time, it became less. In Assam, there is that practice, but it is not confined only to those states. In Delhi also, there are some stray instances. In Maharashtra, such a stray instance of killing of infants. There's a uh, human sacrifice to appease God, etc. And in Karnataka or Tamil Nadu also, there were certain practices. That's why some laws were made in Karnataka. In Kerala also, uh, there were certain experiences because of which the government is intending to bring out a new law. I don't know whether the law is enacted, but the draft bill was there and it was debated. And it's quite important that such a law should supplement the present legal system. Now, relating to the occurrence of this witch hunting or uh, say human sacrifice or various other types of uh, such a superstition based crimes, when you conduct a research, you have to go to those places and investigative type of acts are to be performed, and there with the help of NGOs or by befriending the concerned community and by educating them, and if possible by trying to avoid occurrence of such instances, you have to conduct research. Action research is that. See, by action research, the researcher tries to give some solution. Some result will arise out of that kind of research. See, when a researcher finding is just decorates the shelves of a library, but it does not come into actual practice, it may not help the society. Legal researcher should help the society invariably and essentially. That's why if the researcher sees to it that there is an avoidance of occurrence of that crime, then there is an action research. And for that purpose, he has to befriend the NGOs or collaborate with the governmental agencies or the education institutions or the social leaders, so that by convincing them about the desirability of some just and fair principles under the constitution or human rights principles, how the present social practices are to be pruned and they are to be simply avoided. About that, he or she has to convince. And for all these purposes, conducting a qualitative legal research becomes essential. See, uh, quantitative research may not help. It may be providing certain hints about the extent of the problem, uh, in how many numbers that it occurs, how frequently it occurs, and what are the issues involved. That's statistically or economically, demographically, what are the uh, basic issues involved in that kind of a society. About that, quantitative research may be helping. That's the extent of illiteracy, extent of poverty, extent of ill health, and so many other factors might be helpful. But what is the mood of the people, what is the emotion, what is their feeling, and how much they are committed to their own beliefs and practices, and whether they are prepared to give up those practices, or whether they simply rely upon the witch doctors' views, or the views of some say medical medical practitioner of that place. There's a quack, a medical quack of that community, etc. About all those things, when you ask questions and get answer, directly or indirectly or by observation, you are actually building a new knowledge. You are generating a new knowledge. In fact, research is nothing but generating a new knowledge, in order that ultimately that knowledge will be helpful in safeguarding human rights, promoting justice, and promoting welfare. Because knowledge is purposive. See, in the field of legal research, knowledge should be regarded as a purposive, because legal research should ultimately promote the cause of welfare and eradication of various types of injustices, discriminations, and unfairness. Having said about the nature of qualitative legal research, let me explain the types of qualitative legal research, or categories yes, for the purpose of analysis. Such a categorization becomes essential. See, goodness of a qualitative research much depends upon the experiences of the community, as expressed in various circumstances. There are four such specific circumstances about qualitative research. The word qualitative itself points out that it stands for a good quality, uh, so that the natural and realistic considerations of the society is the basis for generating knowledge. That's why it is a quality. It is qualitative. See, qualitative research can be conducted in the field of doctrinal research also. See, when quality is the concern in the field of research, how it is to be promoted in the field of doctrinal legal research? By being objective, by avoiding various types of biases, by avoiding various irrational elements and such things, that doctrinal research is to be conducted. By that, qualitatively, that research will be better. But here, the term qualitative is used in a specific sense or technical sense, that it reflects the research based on natural setting of the society, natural or realistic factors. The first category of qualitative legal research relates to description of processes, relationships, settings and situations, or system and people. About the people it may describe, or about the system it may describe, or about the processes it may describe. For example, how exactly rape trial is conducted. About this, there could be very objective narration of the whole uh, of that process. There's a from the moment of filing of a FIR to the last stage of conviction or even the final decision in an appellate court. The totality of the process is going to be qualitatively analyzed by the researcher. See, there are so many participants in this legal process. The police officer who records, the medical examiner, or the forensic uh, expert, their participation will be there. How exactly they treat this rape case? Whether they treat a rape case in a different manner than the ordinary case, or whether they're careless, or whether they're uh, uh, not acting with any feminist perspective. See, uh, women as victims of a crime have certain disadvantages in the society, because society is basically uh, has a patriarchic features. That's why all these officers who are usually men folk have certain inbuilt biases or inbuilt approaches relating to women issues, whether they are pro women or whether they are biased, or whether they are simply mechanical in their course of official functioning. About all those things, when you are gathering data and making certain inferences, then you are actually qualitatively assessing all those natural factors. See, subsequent trial in the court also, their participation by the uh, public prosecutor, the approach of the judge, then how exactly questions are asked and answers are given, or how the lawyers argue, even relating to some of the unimportant issues. Suppose they are raising such a matters, even though the woman's character is not a material factor at all, but in course of their argument, they use such arguments just to win the minds of the judge. Then uh, how the whole adjudicative system is not uh, acting in favor of women, about that it's possible to draw certain inferences. I am suggesting you to go through the brilliant book, a very scholarly book by Professor Pratiksha Bakshi. There's a that's about a rape trial. Uh, the public secrets of law, public secrets of law, the rape trial. There's a published by Oxford University Press, and she's a very eminent researcher who is identified by Infosys Foundation recently as the eminent researcher. She narrates all these incidents and how exactly she conducts that qualitative legal research. About that, perhaps a very good example can be found by reading that book. Of course, she makes use of observation as a method. Then ethnographic study is her major tool. Then she conducts a case study. Then she conducts a interview, and through questionnaire also she collects the data. But a questionnaire is not her main tool. Interview is her main tool. Interview and uh, this ethnographic study. Ethnographic study conducted through observation. Thus, through exam, I mean, by describing the process qualitative legal research can be conducted. Then how exactly the police conduct their investigation about the extent of a third degree method of investigation about all those things. There could be description. That's also part of a qualitative legal research. Then what is the relation between lawyers and clients? Now, about the study of the bar as a whole, the structure of a bar can be studied. From various perspectives, it can be studied. See, whether the lawyers are influenced by the factors of caste or factors of, say, religion or factors of language in the course of their relation with their clients. See, in a civil cases, there may be one approach. In a criminal cases, there may be different approach. The concerned client might be more interested in winning the case rather than promoting a lawyer of his own caste. See, there might be mixed type of approaches on the part of clients as well as the lawyers. Lawyers are preferring clients of their own community, or lawyers using the touts or some middlemen to get the clients. See, what the type of relation between a lawyer and the client? How exactly that a relation is formulated, either in the form of a contract or some understanding about the payment of a fee, about adjournments, and in how many months or how many yes, how many months or year that the case shall be completely decided, and the final decision should come. About all those things, there will be such relations. Then similarly about the situation of a people or a situation of a community or group also, there could be such a description. All these are areas of description. For example, what is the status of a scheduled caste who are belonging to the very low income group or a low literacy group. See, all the scheduled castes are not belonging to same type of situation. Some of the scheduled castes, because of their occupation or because of their situation, do not have so much of education or so much of uh, access to employment or access to economic opportunities. Because of these factors, whether inner reservation may be appropriate. Suppose that question is going to be asked. See, when Raju Commission in Andhra Pradesh conducted research, it conducted research by using a qualitative method. How exactly among 4 categories of scheduled castes out of 106, the variation is drastic, and because of such a variation, the constitutional goals of justice are not going to be satisfied at all. About that, it gives some suggestion that by going for inner reservation, there's a grouping of various castes, so that among those groups, there could be distribution of entitlements. 15% posts or 15% of the seats shall be distributed according to particular formula, so that all the 4 groups will be given equitable representation, not equal representation. Of course, the Supreme Court said that nothing doing. Scheduled caste means scheduled caste. All scheduled castes are equal, and there cannot be inner classification, micro classification at all. That is one approach in a E.V. Chinnaya case. But subsequently, there was a different view, but still, E.V. Chinnaya is not overruled at the position. But how qualitative research can bring out all such uh, factors or all such factors of a social scenario. About this, we get a good example. For example, uh, in a Kolkata or Bombay, in uh, a red zone area, uh, what is the treatment accorded to prostitutes, and what is the position of prostitutes, and how exactly the interests of sex workers are protected or not protected. About that, when research is to be conducted, qualitative legal research is helpful because it focus on natural setting of that community, and comes out with some findings which are realistic, speaking about the objective situation. The second category of qualitative legal research is the area of interpretation. Now, suppose you study the behavior of certain professionals like doctors, or say the lawyers, or even politicians, parliamentarians, or such a class of people. See how exactly they behave in a particular situation. About that, qualitative research will be of great help. For example, how do parliamentarians behave in a voting, voting within the house, in the circumstance of a defection, or in relation to other matters, or in approving a controversial bill? What is the approach of these legislators? Now, suppose about the approach of legislators in approving a controversial bill, a study is conducted. Then you may be coming with some finding that yes, parliamentarians are quite bold enough to reject some of the controversial bills, and they're not in favor of approving those bills. Or there may be other viewpoint also. Even with the bitter criticism against a bill initiated by the central government, all the members of a ruling party in the parliament simply voted in favor of the bill. I'm referring to this farmers bill. There were three farmers bills, and there were some internal opposition, and some of the political parties which were part of NDA simply quit MDA and went out. Akali Dal is one. See, in such a situation, what was the behavior of the parliamentarians? Parliamentarians simply acted on the basis of the uh, party whip's instruction, because a three-lined whip was issued and it became mandatory, and then there was no such a option on their part. See, there may be so many other instances also. For example, during the times of Rajiv Gandhi, Muslim women uh, protection on divorce bill was initiated soon after Shah Bano case. And uh, of course, the Congress party which was in a majority, had a huge strength. But there were certain members, for example, one member, a prominent member of that political party, is a uh, he is a presently governor of Kerala. Uh, what is his name? Shri Arif Muhammad Khan. Shri Arif Muhammad Khan was bold enough to uh, oppose the bill. He simply opposed the bill because his conscience was in favor of Shabanu judgment rather than with this bill. So he opposed the bill. There were such instances. How exactly judges behave? See, during emergency, Justice H.R. Khanna gave a sole dissenting judgment. See, interpreting the behavior of those types of personalities, that's also involving certain amount of qualitative research. The third category is a verification of assumptions, theories, and generalizations. See, there are so many theories or so many propositions or hypotheses. Okay, so not a theory. A theory becomes uh, uh, an approved hypothesis. But when there are certain propositions or hypotheses or some idea, formulation of a certain notion, testing of such notions or generalizations can be done on the basis of a qualitative research. For example, there is one assumption that trafficking in women takes place because of the economic reasons, economic compulsions. Because of economic compulsion, women of a vulnerable group or vulnerable age enter into that profession. They agree themselves to offer their life as sex workers. It's a sheer economical compulsion. Now, suppose in some of the economically poorer sections of West Bengal or even Bangladesh or in Nepal, women are taken or women are offering themselves to uh, enter into such a profession. They agree for certain contracts and get money and say uh, finish some of their family hold responsibilities. Actually, it's because of economic compulsion that they enter into such a profession. This is an assumption. But is this assumption appropriate? Is it correct? When we conduct a qualitative legal research, we find that many women enter into that profession not because of economic compulsion, but because of some criminal act of a kidnapping, or they are victims of some cheating. They are offered with certain jobs, but it is not a job. It is not. It is only a white slave work that they should involve in. They realize only at a later period. And there are also some instances where the sex workers voluntarily, knowingly persuade their own children to enter into the profession? Is it out of economic compulsion? Prostitutes of advanced age, I mean, prostitutes which for of a middle age who can maintain themselves, they need not drive their children into sex trade at all. There is no such economic compulsion. But why they do that? Because of their uh, say complaisance with the circumstance, or their compromise with the situation, or with the belief that this profession is also okay, that they allow such a thing to happen. See, it is very surprising that some well-to-do sex workers compelling their own daughters to enter into that profession. It's a surprise. But when we conduct a case study, when we observe or when we collect a whole of data pertaining to that background, then we'll be able to test the hypothesis whether women enter into the profession of prostitution out of economic compulsion. Similarly, there is one notion that economic backwardness is the root cause of social backwardness. This is one idea floated in a MR Balaji case. Economic backwardness is the primary reason for social backwardness. In a Jayashree case and various other cases also, that was reiterated. But is it correct? Now, suppose there is a social backwardness, but there is a economic affluence, or there is a adequate property, adequate income, and so many other things. Then the individual can overcome the situation of social backwardness. That's why in Indra Sawhney case, the Supreme Court introduced the idea of exclusion of a creamy layer. Exclusion of creamy layer. See, whether it withstands the real test about this when we conduct research, we will be able to know whether exclusion of the economically advanced sections from the reservation group could be appropriate or not. The fourth category of analysis under qualitative research is evaluation of policies, practices, and innovations. See, there are certain policies which are newly introduced. For example, street vendors are given certain types of protections. Of course, Street Vendors Act was made. See, one could generally expect that since street vendors are the exploited masses, or they are subject to lot of inconveniences, they should be given a lot of facilities and assistances. Street vendors, they face several challenges. See, they are haunted by policemen, harassed by health authorities, and they are again put into various types of exploitations by the corporation or various other local bodies. In addition, there are so many local gundas who are involving in a certain exploitative acts against these persons. See, it is essential to protect the vendors from these types of exploitations, they should be given economic security, and they should be given certain facilities. For example, against rain, or against the burning sun, or against the winter. They should be given some protection. That's why some shelter or some permanent place is required, and simply uh, bearing the uh, wind, the materials, and uh, going on hawking and selling the materials cannot be regarded as appropriate. Suppose all these expectations are there on the part of the society, as well as the people belonging to these communities. But what is the law that was enacted for the protection of the street vendors? The street vendors law generally provides for avoidance of crowding, or avoidance of, say, public disorder, or keeping the streets safe, and keeping the streets not crowded by these vendors. Can it be regarded as the sole purpose of that law? Of course, marginally, if there is some other provision which says that for their welfare, appropriate rules may be made by the state government. It is left to the state government to do that, and state government may do it according to its convenience. Suppose a researcher conducts a research, comes out with a assessment of this legal policy from the perspective of the society, that really the vendors shall be given protections against these types of uh, uh, economic and social challenges, physical challenges, and it should not be just confined to exclusion of overcrowding in streets. See, this kind of analysis could be there only if the researcher conducts research by making use of qualitative method of conducting the research. So far, I said about the types or categories of qualitative legal research. Then now let me briefly discuss about the steps that are involved in qualitative legal research. See, like any other legal research, it should have a research design, or there should be a statement of all those details about the research that is going to be conducted. There's a title of the research, then the specific area taken, its scope, and uh, of course about the duration within which it is going to be completed, and all those aspects about research proposal that will have to be briefly addressed. But a research design should speak about the specific things, like framing of specific research questions. See, a qualitative legal research becomes quite effective along with use of various questions. For example, about honor killing. Suppose the researcher comes with the specific questions. Uh, what is this phenomenon called as a honor killing? Why that it occurs? Where does it occur? And because of whose persuasion that it occurs? If it is a Kap Panchayat, what is the nature of this Kap Panchayat? whether a Kap Panchayat has any legal basis. Then what are the statutes that are available for protecting the people against this honor killing? See, Law Commission has conducted some research. There are so many judgments relating to honor killing. All those doctrinal developments are there. But a qualitative legal researcher will be asking these specific questions. Why is it that it occurs? See, a caste-oriented society or a society which is orthodox and not tolerant about intercaste or interreligious marriages or a violation of a Gotra principle, etc. Then, in such societies, those things occur. See, formulation of these research questions become quite important in order that qualitative legal research becomes successful. Even in other areas like, say, yes, in other areas like protection of children against the Sexual Offenders Act, there also questions may be posed appropriately relating to those matters. Then next step is a choice of appropriate tool for a data collection. See here, we come across tools like a case study, ethnography, observation, interview, audiovisual recording, documentary analysis. These are various tools of data collection. The choice should be such that through such tools, relevant, exhaustive, and unbiased collection of data should take place. I don't have time to discuss each and every tool of data collection. Perhaps that might have been discussed somewhere else, or you can read independently. But I am pointing out that these tools are to be used in an integrated manner. For example, or the use of a particular tool might be cross-checked by application of another tool. For example, through case study, you collect some information, say about the position of domestic workers, domestic maids or domestic workers. You are conducting the research, and say out of say 100 uh, domestic workers, you are choosing about 5 workers for a case study. 5 workers for a case study. 5, or it may be even if possible 10. 5 is also okay in a particular circumstance. See, whether the concerned domestic servant is subjected to any kind of exploitation in her home, or are there violations of other laws, for example, child marriage law, whether child marriage law is violated, or whether she is subjected to child labor practice or hazardous works, and so many other things, such issues might be there. About that, So through case study, you arrive at some conclusions. That is to be cross-checked by the general data that is available relating to the domestic workers in a general. Then what is gathered through interview may have to be cross-checked by the data collected through questionnaire. That's even about tools of data collection also. If you go for a combination, there is a possibility of avoidance of errors. Then sampling. See, it is not possible to conduct a qualitative research by keeping the universe as a whole and collecting data from the universe as such. Now, suppose from a community belonging to displaced sections, there's a because of say construction of a dam or because of construction of some public work, people of that area were evacuated. They were shifted to some other place. Whether adequate rehabilitation has been done, whether they were given adequate facilities, about all those things, suppose you conduct a research. There, suppose there are about 2,000 persons who are displaced and who are living in a particular camp. Conducting interview or ethnographic study of all the 2,000 persons becomes impossible, because you have to complete your research in a period of say 3 months in case it is a short-term research project, 3 months or 6 months. Or if it is a PhD work, suppose you have a maximum duration of 1 or 1.5 years in which you have to complete a whole of your field work. In such circumstance, it is not possible to approach all the 2,000 persons. There you have to go for a sampling study, and here sampling of different sorts can be used. There's a random sampling, then a structurized sampling, or purposive sampling. Uh, Different types of sampling are there, and one is to make use of appropriate method of sampling so that qualitative legal research can be conducted in an appropriate way. See, then data collection. Here, the researcher should generate data by using various tools, and some ethical principles are to be applied here. See, uh, of course, there shall be uh, avoidance of total bias. Total avoidance of bias should be there. Then uh, the participants' consent should be obtained before conducting an interview or before such a participation. Then researcher shall not put the participant into any kind of physical or mental harm, and confidentiality is to be maintained, because his identity shall be kept intact, and it shall not be disclosed at all. Who gave this particular information about that? There shall not be any such a disclosure at all, and there are certain norms. There's ethical, there's the legal, the research ethics which are to be meticulously followed before entering into such a process of data collection and participation by that person. Uh, he shall be ensured about maintaining confidentiality, and Of course, there shall be avoidance of all such harms, etc. Then, in the course of an ethnographic study, the participant observer or researcher should attempt to obtain complete sociological data by observing a social event. See, uh, ethnographic study should be conducted in such a careful manner. As a field notes should be kept, and uh, then the non-participant uh, um, non-participant observation. There uh, there shall be minimal uh, interference. Then field notes should be kept properly, and uh, there should be proper recording of notes and such things. Then relating to interview also, certain norms are there. Those norms shall be followed. Adequate planning of interview shall be done. For that purpose, the researcher should prepare the interview schedule, and he should go for asking of appropriate questions uh, in course of interview. This is considered as a very effective method of data gathering, because on the basis of one's own experience, that a person will be divulging that information to the interviewer. So between the interviewer and interviewee, there should be such a nexus that interviewee should not be put into any kind of pressures, fear, or exploitations. But the researcher shall be a researcher should collect data in an appropriate manner. Then a case study, here also the researcher has to uh, appropriately organize the whole planning of this case study. How exactly he is going to conduct a case study? About that, he should come with the proper planning, and he should execute that planning accordingly. And about the preparation of a questionnaire also, see, there regard shall be had to simplicity, communicability, and it should inspire interest in the participants. Then next step after a collection of data is analyzing the data. See, in analyzing the data, the researcher may go for a classical content analysis, or discourse analysis, or ground theory analysis. Three types of analysis can be resorted to. Insofar as a classical content analysis, see, qualitative legal research might be conducted by gathering a lot of documents. For example, a personal diary, or letters, or various other communications made by individuals. For example, when you are uh, conducting a biographical research of a Chief Justice of India, there, what are the communications that he had with the various other constitutional authorities, with the president, or with the law minister, or with the fellow judges, or with the high court judges, and how he resolved various issues related to uh, distribution of cases, or various other issues, or formation of various benches, etc. About all those things, so many information might be available there. uh, Confidentiality is to be maintained. Then content analysis to be done in a very careful manner. See, uh, what is the type of material that is going to be analyzed, and what theoretical inference can be drawn from the content, and what is the abstract of the information contained in that letter or diary or so many other thing about that you have to uh, keep in mind, and then you have to summarize. Now, suppose he has a certain writing about say law's role, or about a role of particular institution, then summarizing and evaluating the content of it, that can also be done. That is one method of content analysis. See, uh, content analysis of letters or documents or a diary or even a will or various other types of legal documents. That's also one thing. Now, suppose so many of the family settlements are simply uh, defeating the interests of women. Then content analysis may point out that, see, the latest effort of the law is simply defeated by resorting to this kind of deviation. Then discourse analysis. See, there are various uh, uh, specific concepts or specific ideas around which whole discussion revolves around, uh, especially during a conversation or during the observation. The researcher might be getting some data, and about the text of that material. For example, from a tribal community, you come across some text of their social customs. You are analyzing it. The cultural background of that material can be taken into consideration. Then item-wise analysis of various subjects and objects can be done, and mapping the network of relations with the community as a whole. This is how discourse analysis of qualitative legal research is to be done. Thirdly, grounded theory. See, qualitative legal researcher may not go ahead with any legal, any hypothesis at hand, or any particular proposition in his mind. In other words, some advanced legal proposition might not have been put forward by him, but in course of his research, he develops a theory. There we come across all these principles, how he can uh, say improve that theory about that we come across some propositions. What I intend to point out is that it is not a must that the researcher should come with a ready-made hypothesis. In a non-doctrinal research or qualitative legal research, the researcher may develop a theory in course of time, because from time to time, when he goes on collecting more and more data, he may find that there is a need for such an analysis, and he may go for such a discussion. Then last stage is a generalization. Here, the researcher has to generalize, or he has to uh, arrive at a certain conclusions on the basis of inductive logic. It is a inductive logic which becomes very much appropriate here, not a deductive logic, because on the basis of vast experience from various data that he has gathered, he will be arriving at such a conclusion. Thus, whether it is relating to witch hunting or whether it is relating to, say, uh, car panchayat or relating to any other matter, some generalization can be brought out in that way. Further, the data collected during a qualitative legal research shall not be usually applied in a subsequent qualitative legal research, because that's the general impression that the scholars have. Scholars raise objection against use of data collected in a qualitative legal research for a secondary analysis. See, once a researcher collects the data for a specific purpose with a commitment to the participant that it will be used for a specific purpose, etc., then making its use for some other purpose becomes quite problematic. That is why, as far as possible, it shall be avoided. But there are some circumstances where the data collected constitutes the public archive itself, or when it constitutes a public domain or knowledge that could be shared with the public at large, then it can be used, but it shall be used with a lot of care, and there shall not be disclosure of the identity of the participant of a researcher. These are all general aspects related to qualitative legal research. Yes, about the significance, I have already told in the beginning that there is a growing significance of this field of legal research. It is unique, it is quite important, and there are vast areas in which it is possible to conduct qualitative legal research, apply this in an increasing manner. But unfortunately, we don't have experts in this field. There is a need for developing expertise. Whereas the participants in this workshop might be developing some interest in empirical research, including the qualitative research, and qualify themselves as a fit for conducting research in course of time. Because when there is a new challenge that uh, through qualitative research, the actual voice of the society shall be heard, and it shall be the basis for a formulation of a policy. It is appropriate to follow that proposition. With this, let me conclude. Thank you very much.
Thank you, sir. So there are a few questions raised in the chat box. May I read it out to you so that you can answer them?
Yes, let me try.
Okay.
Okay,
So
research,
Priya
there is
Anuragini
no
asks.
absolute answer. Okay.
Yes, sir. So the first question is, if research is on women refugees who may be suspicious of the researcher, what may be the appropriate approach of collecting data?
Research topic is about a refugee.
Yes, sir. If the research is on women refugees who may be suspicious of the researcher, what may be the appropriate approach of collecting data?
What refugee you told? Refugee?
Women refugees who are
Women refugee.
suspicious of the
Okay.
researcher.
Okay. Okay.
Yes, sir.
Yes. Women refugees have distinct problems. There, the collection of data could be on the basis of interview as well as a case study. Interview, case study, that approach can be adopted. Then about designing, your question is about how to approach. Then
Yes, sir.
particularly what type of research questions are to be posed. About that, first you have to be clear. See, the questions may be about their economic security, their physical security as well as sexual autonomy. See, there might be various situations of sexual exploitations which they might be put into, and how the state in which they were given refuge or asylum or under a responsibility to protect their interests. About these research questions, one should think. Then about tools of data collection, there of course survey through survey it is possible to know how many numbers of refugees are there, what is their economic position, how many dependents are there, how many children are attached to those women, and whether the women uh, uh, have the problems of say separation. There's a whether they were separated from their husbands because of journey, because of say war related crimes, or because of other factors. How many of them are with a marital relation? How many are widowed, or what is their position as mothers? About all those things. Then what the current situation, what type of economic security is available, and uh, of course about the adequacy of facilities that are available in the concerned refugee. For example, women refugees of Nepal, yes, uh, Tibetan refugees in near Mysore, or some other place. There, how the Tibetan refugees are developing their self-employment skills. Suppose that for a long duration that they are there. See, in a short duration there might be some type of problems, but if the refugees live for a long duration in a country, for example, in a uh, uh, Mysore and various other places in Karnataka, the Tibetan refugees continue to live as refugees for decades together, from 1964 to 2022, for about 55 years. They have been residing in Karnataka, and in course of their long stay in India, what are the problems that are faced? See, what type of refugees? First, we should know what are their problems, and whether it is a long duration refugees or short duration refugees, and what are the problems faced, and what type of economic facilities are there. See, educational facilities, then language problems or ethnic problems, there are job opportunities. About all those things, questions could be there, and data collection, then analysis, generalization. In that process, in that way, the progress is to be made. Yes. Any other question?
Yes, sir. The second question is about the ICMR in their ethical guidelines for human and biomedical research require the investigator to follow certain specific guidelines when he conducts research on vulnerable sections of society like children, HIV patients, etc. Will you kindly clarify how far a legal researcher should follow such guidelines?
See, legal researcher has a responsibility to abide by ICMR guidelines, because the uh, the guidelines that are binding in the case of uh, biotechnical or biomedical uh, spheres shall have to be applied by the legal researcher also. So it's quite appropriate that ICMR rules are to be followed. See, uh, there we come across ethical principles laid down in a very specific manner. It is not that difficult to comply with those requirements. And as a legal researcher, you should not find it difficult to follow those norms, because those norms intend to protect the right to privacy of those participants, right to privacy especially. Their, I mean, non-disclosure of identity, then non-subjection to any kind of physical or mental harm or such things.
Okay, sir, there's one more question. Is a qualitative research methodology appropriate for a major project that covers the whole of India? And if in such a qualitative research, saturation of data occur at a high number, how can content analysis be conducted effectively on such big data?
Uh, See, for whole of India, when you conduct some legal research, uh, of course, qualitative legal research has certain difficulties. For example, uh, relating to death penalty, some qualitative legal research is to be conducted through interview about the position of uh, death convicts uh, who are undergoing that mental harassment. That, they are not hanged, but still they are continuing as death convicts. Suppose uh, through interview that research could be conducted. It may uh, require interview at various places, and it is not that difficult uh, to conduct such kind of research. But uh, when the research work is shared by various entities or various persons or various groups, then it is possible to share the burden. Uh, See, about qualitative research that could be conducted about the working of juvenile justice boards or children welfare committee works, or say protective home for women or such a thing. Since localized and regionalized research becomes essential, it's not possible to go for a national level research unless there is a perfect coordination. See, uh, it's possible to conduct research. Uh, See, for whole of India, suppose such kind of a planning is made, and uh, some common pattern related to research questions or about data collection tools or about choice of samples, etc., are done in a appropriate manner. It is possible to conduct a research. For that, uh, perfect coordination is required, and adequate planning is required. Nothing is impossible. Uh, Adequate planning is required, but qualitative legal research is usually based on a field work. That's why this difficulty is there. So, if you connect all the experiences of various parts of the country under a common scheme, then it is possible to complete the project. Yes.
Thank you, sir. Are there any more questions?